I think we're going to start, if it's all right, even though people will be streaming in for a few minutes more because we have a tremendous amount of ground we want to cover tonight, and we don't want to intrude too long on everyone's time. So welcome to you all. My name's John Kieran, and I'm president of the New York City Bar Association and also co-chair with Sharon Katz of the task force established by our state's Chief Judge, Janet DeFiore, to address, try to marshal and try to enhance as much as possible the New York lawyers' volunteer commitments to helping out the victims of Hurricanes Harvey, Irma, and Maria in Texas, Florida, and Puerto Rico. And it's an extraordinary call that our Chief Judge made, and it's a great opportunity for us to embrace that call. And it's just a pleasure to see all of you tonight. I know others are coming in, and also a pleasure to welcome the significant number of people we understand are participating in this event by live stream. As often happens in disasters like this, the need for legal services to assist the victims tends to ripen sometimes on its own pace. And the very first instances after the disasters, when sympathy for the victims is at its greatest, the tendency is for humanitarian needs like food, medical supplies, shelter, and the basic necessities of life to kind of overwhelm all other needs. And the legal needs tend to be concentrated in manning hotlines or manning tables at disaster relief centers in ways that tend to get covered by people who are local and admitted to the local bars. In responding to Chief Judge DeFiore's call, though, our task force has understood from the beginning, and I think others have understood, that the ripening of true, substantial, genuine need for large amounts of volunteer legal assistance far beyond the resources of the local bars in these places was certainly going to ripen over time, and it has. And that's what makes our gathering tonight particularly timely. The particular focus of tonight's event is going to be on assisting hurricane victims in their appeals from denial of FEMA benefits. And we've selected that area to focus on really for three reasons. The first is that the needs associated with appeals from denials of FEMA benefits are massive. Just to give you a sort of overall sense, our friends at FEMA have told us that approximately 4.5 million people have applied for FEMA relief. On any percentage that you attach to predicted denials of benefits, you see that the numbers of people who will be needing assistance in connection with the denials of benefits are going to be huge themselves. Second, FEMA appeals, as directed to a federal agency, have the particular advantage that distinguishes them from some of the other legal services work needed by victims of the hurricanes, that it can be done by people who are not admitted to the local bars. And so that provides a particularly useful niche for us to try and embrace. And third, the FEMA appeals knowledge base that you need to be able to assist victims is a knowable and embraceable knowledge base. As you'll see, you'll get a lot of the framing of it just from this event tonight, such that once you learn it, you can be somewhat readily able to help people who need to bring these appeals. And once you've done a few, you can help a significant number of victims for what is really, for volunteers, a manageable amount of time. So tonight's program has two main components. The first will be a substantive training on how FEMA appeals work. And in that training, we're taking a somewhat different approach that we hope you'll find useful, and we're grateful to our colleagues for providing, which is that the first presenters on that subject will be people from FEMA itself, to whom we're tremendously grateful for your commitment of your time to come join us this evening, who will give us some significant and really useful perspective from within FEMA about how the FEMA process will work, how the appeals process will work, what the substantive law is, and how they see the FEMA appeals process is working, which is kind of invaluable insight for those of us who will be providing assistance to people bringing appeals. We'll then complement that presentation with a presentation by an advocate who has developed tremendous expertise in processing FEMA applications and appeals over the 5 years since Hurricane Sandy. And I'll leave it to Tom Maligno, our next speaker, to introduce them in detail. But we're very grateful to all of you for coming. The final 20 minutes will be directed to the nuts and bolts question of how do I go about volunteering? And we'll talk to you about a variety of different ways of potentially volunteering. You can assist at a clinic here in New York that is operating up in East Harlem for people who have moved from the site of hurricanes, mostly but not exclusively Hurricane Maria and from Puerto Rico, to New York City when they were displaced from their homes by the storms and they need help here. We can talk to you about how you can participate if you're at firms through assignments being channeled through the Association of Pro Bono Counsel to the firms. We'll talk to you about an offering that we're going to develop here at the City Bar Association, where volunteers can gather on Monday nights with other volunteers. Bring your laptop, and we'll provide the pizza, and you can work together with and consult with each other and with colleagues who are particularly knowledgeable and can answer some of your substantive questions. In part of and hopefully with some sense that convening also increases the enthusiasm and sense of collective communitarian effort on our part to be of assistance to these victims. And we could talk to you about how you can volunteer directly. This is obviously important work. We hope very much that on obtaining this training, you will volunteer. This is work that can change lives of people who very much need the help. We hope that you will hear the call from Chief Judge DiFiore, and will hear your own call to do this work. So with that, thank you all for being here. Thank you all who are on live stream for joining by live stream. And let me hand the microphone over to Tom Maligno, who's the Director of Pro Bono and Public Interest at Toro Law School, where he has developed a tremendous amount of experience in assisting disaster victims over the year. And again, thanks very much for coming.
Thank you, John, very much for hosting. I am very excited to see you all here tonight, and let me just briefly tell you why. When Hurricane Katrina struck the Gulf Coast, law schools from across the country created the Student Hurricane Network, and en masse, we rotated different schools and went down and made a significant difference in the lives. So that was law students who were able to do that. Our students at Toro were still doing that when Sandy hit the Northeast, and we decided to redeploy ourselves to New York, where we became involved with a lot of our colleagues like Will and people from legal aid and legal services programs and pro bono attorneys from bar associations across the Northeast. At Toro, the need was so great that we developed a clinic. We hired Professor Ben Rajat, who was the head of our clinic. But then something interesting happened. FEMA asked Ben and I to become special attorney advisors to assist them with the Sandy claims review process. And so I've had the chance to see this hurricane or disaster relief from many sides over the years. And the one important lesson that I've learned is strong advocates do make a difference. And the earlier you are involved in the process, and the more you know about FEMA and the other recovery programs, the better advice, of course, you can give to the homeowners, and the quicker their claims can be resolved. And the best way to do that is actually to talk to the experts within the agency who are not the enemy, who are here actually to carry out the law. And so I am very grateful that my 3 colleagues from FEMA came up from Washington today. They're all not going to get home till after 2 o'clock this morning, so I appreciate the fact that they're here to talk with us. And since we do have a full program, I just wanted to emphasize again the importance of what you're going to learn today in being able to assist people from the very beginnings of their claims process in the hopes that it will never have to go to litigation because you understood the process, you're able to impart that information to your client, and hopefully they'll get a satisfactory resolution as soon as possible. And so I'm going to turn this over now to my FEMA colleagues, all who are attorneys that have been working day in and day out for many, many years, but these last couple of months, as you can imagine, have been incredibly busy. And we're going to start with Chris Page.
Thanks, Tom. So I'm going to be giving the presentation on the NFIP, and we're going to talk about appeals at the end of that. This slide deck we've used on a number of other presentations, so I'm going to blitz through some of them in the interest of time, but you're happy to read them and reach out to us. Our contact information is on the first slide, so if you have any questions, we're here for you. Just a quick, lawyers being lawyers, this is for informational purposes, no legal advice being given right now. So quick history of our program. So on the flood insurance side, back in 27, most of the private companies stopped writing for the risk of flood because the 1927 flood happened and a number of them were wiped out and became insolvent. Congress kicked it around for a while and tried passing authority in 1956, but didn't fund it, and so that kind of died on the vine. In 1966, after a series of rather devastating hurricanes, Congress said, hey, could you guys figure this out? And they came up with, ultimately in 1968, the National Flood Insurance Act. And what you see on the screen is they did it once and then they keep changing it a whole lot sometimes. And so you see a number of acts that Congress has passed in order to improve the flood insurance program. When you have that many laws that deal with flood insurance, you have a lot of different findings and purposes. Some of them might seem in tension with one another. We need to provide a lot of coverage, but we also have to make it affordable. We have to accept everybody who qualifies for flood insurance coverage. So if you ever read through the Act and you go, wow, there's a lot of stuff going on here, there's a lot of stuff going on here. One of the things that's of interest to us right now is the fact that the program has to be periodically reauthorized. This was a program born in the 60s when everybody thought that they would solve all the world's problems in short order. The private industry would step in and take over. That hasn't happened yet. We're celebrating our 50th anniversary this year. And so as a result, our program actually is set to expire on December 8th. Once December 8th comes about, if Congress hasn't reauthorized us, we still have runway to service claims. We just can't sell new claims at that. Sell new policies at that time. There's a number of regulations. We are in 44 CFR, both on the disaster side and the National Flood Insurance Program side. This is just a quick rundown of where you'll find some of the ones that deal with the National Flood Insurance Program. When we talk about the National Flood Insurance Program, we usually refer to it as a four-legged stool. There's the insurance piece of the stool. We have to obviously make and distribute the flood insurance rate maps that help inform what risk you're in if you're in a special flood hazard area. We have floodplain management, which helps us determine, work with local officials and states to adopt codes and standards for their flood insurance and for their floodplains. And then we have a number of incentives, including our hazard mitigation assistance grants and our community rating system, which really works with communities to incentivize, taking good action and mitigating against the peril of flood. So this one's important. Our authority to carry out the program is at 42 U.S.C. 4011, and the flood insurance is for, the quote is right here from the statute, it's for losses resulting from physical damage to or loss of real property or personal property related thereto arising from any flood occurring in the United States. In the policy, you'll see us talk about direct physical loss by or from flood. That's directly tied to this provision of the statutory authority. The other thing that we are allowed to do, there's the federal flood insurance policy has basically a mitigation grant built into the policy itself. So we have this thing called increased cost of compliance. It's kind of like codes and ordinances, that kind of standard. It's basically an add-on to the policy where for certain activities, floodproofing, it's elevating, demolishing. I never remember or renovation. That's it, renovation. We offer up to $30,000 within the statutory limits which are found here. For single-family residential, which makes up the majority of our policyholders, we can sell up to $250,000 to insure a building and $100,000 on contents. And so that $30,000 cap for increased cost of compliance must come out of that it cannot exceed it. You can't go up to $280,000, for example. I'm going to skip over how you buy flood insurance because we're not at that point. But the terms and conditions of insurance, we took the statute, we put our policy itself into regulations, and so all of our policies also are regulations. So one of the things that you'll find when you read cases about the National Flood Insurance Programs, they make a big point about the fact that it's a policy and it's a regulation. And so with that, I'm going to turn it over to Ben, who's actually going to go into the policy itself. You're going to stand? Okay.
Hi, good evening. So I'm going to talk really about the policy itself and the claims handling side, which as attorneys, if you're helping out policyholders, would be the most important part when they're trying to understand what they received and what it's going to cost them to rebuild and how to interact with their insurance company. So the first slide has to do with the 3 different standard flood insurance policies. These are the policies that are codified into regulation under Title 44, Part 61 in the appendices of the CFR. The main one I'm expecting people to be helping with on a pro bono basis will be the dwelling form. This is insuring buildings designed for use as a residence for 1 to 4 families. It's possible you might have some general property forms, which is the second form, or Residential Condominium Building Association policy forms, or RCBAP, which is a third. I'll go into those just, I want to really, I don't have a whole lot of time, so I'll just talk about these very quickly. The hallmark of the dwelling, so if it's a 5-family house, for instance, then you're in general property form territory. General property form is, you can think of it as kind of a catch-all for stuff that doesn't fall into the dwelling form or the RCBAP. The dwelling form is also available for unit holders for certain limited building and contents coverage in a condominium. A condominium can be insured by the condominium association under the RCBAP policy, and the policyholder, the unit holder of the unit in that condominium can buy a dwelling form in excess for certain damage prescribed by the dwelling form within the unit and other limited coverage. The hallmark of the dwelling form is that it pays out on a replacement cost value basis, or RCV. There's a slide that talks about RCV versus actual cash value, or ACV. The way I like to describe it to just ordinary people is ACV is like the yard sale value. It's the used value. Replacement cost is you're going to Amazon, you're going to Home Depot, and you got to buy the stuff new. Okay, so that's pretty much all I want to say about the forms. Okay, so here's the slide for your reference with a more legal interpretation of RCV versus ACV. One thing I do want to say about RCV is that when it does apply, it's not automatically for everything. There are certain building elements that do not qualify for RCV. For instance, carpets, because they're just prone to wear and tear. And there are contents coverage is never provided on an RCV basis. It's always based on depreciated or used value, that is ACV. For last point here, and this, I keep on forgetting to add in Maria. We started this presentation with Harvey and just kept on building it for the other 2 storms. For Harvey, Irma, Maria, the agency has issued bulletins for understanding how the SFIP is actually carried out on the field by the insurers or their claim servicers. You should be consulting the bulletins. You can type in NFIP bulletins on Google and get to them. And so there are 3 bulletins, one for each storm, on on advice and guidance for how to adjust on contents. And we quoted it here, saying that you can use the IRS depreciation. The adjusters can use the IRS depreciation tables as a guide. What is the SFIP? So as Chris mentioned, it's both an insuring agreement and has force of law as a regulation. It's governed by federal statute and it's governed by regulation. The NFIP and the SFIP are not regulated by states and are not subject to state law causes of action. And so just a practice tip here is if you're representing somebody, they got a deadline coming up, you want to file a lawsuit, don't file it in state court. That'll be one of the last slides here about the venue and the limited waiver of sovereign immunity for a suit against either the flood insurer or FEMA directly if FEMA is the flood insurer. FEMA is the flood insurer for approximately 15 to 20% of all policies. And the policy is the same, no matter if it's FEMA that's providing the service or if it's a private carrier that's part of the NFIP that's participating in the program. The policy is the same. The rules are the same. So it's Chris mentioned this, and this middle bullet looks like it was written by a lawyer. The NFIP is based on the principle of indemnification for proved and approved, covered and non-excluded direct physical loss by or from flood to insured property. So actually, I confess, I wrote that because there's a little sequence of things that you have to go through to understand, is something eligible for coverage, is it covered, and what's the proper value for that, that item, and I'll go through that a few slides up. It's not what's known as an all-peril policy. It's a single peril policy for flood, and it's also not a valued policy, which means it depends on an adjustment for that is scoping out what was actually damaged by or from flood, and the value is based on that. What is my SFIP? While the policy is the same, policyholders may have and will have different housing types and ages of construction, different coverage types. For instance, like not an issue in Houston, for instance, really, but if the home has a basement, basements have limited coverage under Section 3A, 8, and 3B, I always forget 2 or 3, for items in a basement. So there can be different coverage types. Even if something is directly damaged by or from flood, it may not be covered or it may be excluded. And different limits of liability. So the policy is the same, but on a factual, fact-by-fact, case-by-case basis, the amount of payment can be different. The SFIP is organized to include, I should have had here, I keep on forgetting to add this too. Section 2 is the definitions. These are my go-to sections, and it just outlines how an insurance policy is generally organized. Section 2 is the definitions. Section 3 is what's covered, the property covered. And so the main ones here are coverage A, which is building, and coverage C, which is contents, coverage D, which is increased cost of compliance, and Chris mentioned that a little bit at the start. Section 4, property that's not covered. For instance, we don't cover, generally don't cover stuff outside the building. And Section 7, exclusions, speaks to the fact that it needs to be directly physically damaged by or from flood in the way that's laid out in the policy. Section 7, general conditions, this is kind of the catch-all section of the policy, talks about things like proof of loss, very important. Section 7J, loss settlement, Section 7R. And so please do consult Section 7 when you're helping people. By the way, our contact information for Chris and myself from the NFIP is at the start of this slide, including phone and email. We really do want you to contact us if you have any questions, you're encountering any problems, you're helping somebody, and they're hitting some walls. We want to be here to help. We view ourselves as partners in the recovery. We want to be able to, I personally want to know if you're facing problems because I want to find out what it is and I want to stop it. Additional agency resources, agency claims manual, the flood insurance manual, and the NFIP bulletins that I mentioned, and the links are here. What should you do if you're a policyholder or representing a policyholder or helping a policyholder, advising them, and there's a loss? The very first thing that we have to iterate and reiterate is documentation. Photographs. Photographs are very, very important. As soon as they can safely be taken photographs, video in addition, augment it with video. Video is great. It can be fill in some gaps, can be very helpful. But in terms of transmitting images to the insurer, photographs are the most important thing of the loss and the property damage. Do it at all stages of the loss, including, if you can, go back in time. Find pictures of birthday parties, hopefully, when I got my house, I walked around the outside and inside, and I took photos of everything, took a few videos. Get baseline photos as much as you can. If there was a prior loss in it, get those photographs of the prior loss and the repairs after the prior loss. The baseline helps to set the indemnification standard because we're paying for what you had there beforehand, not necessarily exactly what you're going to be rebuilding. Photographs immediately after the loss, we're obviously past that stage now. I think we're somewhere in between 2 and 3, stage 3 during all stages of repair and replacement. And finally, 4, the after photos once complete. Make an inventory of damaged contents, take a photograph of the make, model, and serial numbers of things like mechanicals and other appliances. My little practice tip here, it's helpful to date your photographs, or at least to but I rarely have ever seen it, and I've seen hundreds or thousands of claim files, maybe just a handful of times. But it's helpful to understand when the photo was taken, of course, and to identify it. So for instance, if you take photographs of contents and the contents are in a basement, they're not going to be covered. So identifying the location of where they were is important as well. Contractor documentation is kind of the other side of this. Fact experts who are working with the policyholders who can actually speak to the amount that it would cost and is costing to repair and replace the damage that was caused by flood. So contractor documentation, that is coupled with the, and there can be other types of experts that could come in, for instance, a surveyor or professional engineer, depending on the type of loss. If there's a question of rating, or for a surveyor, or if there's a question of causation or structural items for an engineer. These are all things that ultimately are your proof of supporting documentation of your proof of loss. And they should be transmitted as soon as possible and on a rolling basis to your adjuster. The adjuster is basically the windows. The adjuster is basically the window to the insurance company, to a claims examiner, insurance examiner, representing the insurance company behind the adjuster, who is responsible for, the examiner is responsible for paying out proved and approved losses. And so working with that independent adjuster, you can also reach out to the examiner. But working with the independent adjuster is a foundational step. Provide all the documentation that you have. This should be a cooperative process. Cooperative process 2 ways. And I'm not just talking about the duty to cooperate under the policy that exists under almost all policies that I know of. It should be a cooperative process by the adjuster, reaching out not just to the policyholder, but to contractors, other folks that the policyholder is using. If there's any question about what the scope of loss is, or what the price is, or the dimensions, or if a contractor submits, policyholder submits like a 2-pager from a contractor, and the independent adjuster can't figure out how much of that was there before versus how much is a code upgrade, which wouldn't be covered, and how much is an expanded scope of work. Picking up the phone, the adjuster should be calling, the contractor should be calling the adjuster. That's a cooperative process to figure out the proper scope and adjust it to coverage. If that's not happening, I want to hear about it. Prevent further damage. This is basically talking about mold, and all I'll say here, you got a slide. 2 things. Don't fail to mitigate because the adjuster hasn't come out. I know that's too late now, but just general advice. if there are, for instance, debris, contents that are damaged, that are water damaged, take photographs of them in their state, take photographs of them outside on the curb, but don't wait for the adjuster to come in however many days or weeks, because that's just going to cause further damage. There is a general duty to mitigate under the policy, and the way this works is, in the second point, when the damage occurs in connection with a covered direct physical loss by or from flood, it will be covered, including mold that expands as a result, unless there is clear evidence of the policyholder's failure to inspect and maintain the insured property. That's the standard, and that's by bulletin that I've cited. Your adjuster should do a number of things. One of the things your adjuster never should do is ask you for your deductible, ask you for any money. The adjuster, when the loss is significant, should be asking if you want an advance payment to help start on the recovery process before he or she completes his or her building estimate and a final report and submits it to the examiner for review and approval. Work with your adjuster. The adjuster should explain, as I said, what an advance payment is. Work with you during the process to help you show your loss to your insurance carrier. The adjuster is the window to the claim. How you can help thoroughly identifying and providing all documentation that we talked about. Work cooperatively with the adjuster. If you're not in a cooperative exchange with the adjuster, please let us know. The sequence of how an adjuster makes an adjustment is on the bottom of this slide. So we're looking, is the damaged property damaged? Is it eligible for coverage? Is coverage under coverage A for the building, or, I'm sorry, I guess I said coverage C for contents. That's coverage B, coverage B for personal property. Is it covered and non-excluded if it is damaged? So was there direct physical loss by or from flood? Do any exclusions or coverage limitations apply, such as we've mentioned basements, or if you're in something called a post-firm elevated building, and I won't bore you with that because that would take about 30 minutes. There's limited coverage under the same policy provisions I cited for basements. The elements of an adjustment, and so, you know, I've been doing this for 5 years, and I look at an adjustment and it still is, it's a different language to me because I'm not an adjuster and I'm not a contractor, and you don't want me making home repairs on your house. But you can basically outline it into these 3 parts. Actually, I'll outline it simply into 2. First is the scope. That's the nature and extent of the loss and the damage and the amount of work that's necessary to fix it, including the quantity and quality of materials that are required. And so that's scope. It's basically, if you look at an adjustment, it has a series of line items, they're called. Every single line item is an example of scope. And it could be remove and replace. It could be remove. It could be replace. It could be labor alone if there's some added labor charge for the materials that are scoped out for the loss. But that is basically what is termed to be the scope, and that's the scope of the loss. And that's the main driver of the value of the claim. The second aspect of adjustment is what I'll call the quantitative, so basically all the numbers. So it's going to be the dimensions, the units, the quantities, and, of course, the price. Just one practice tip, because I experienced this personally. If somebody starts their repairs, that's great. You know, I mean, we want them to recover, but they should be interacting with their local community in order to understand what their rebuilding requirements may be. If they're deemed to be, for instance, substantially damaged, that is more than 50% of the pre-storm value of the building, replacement value of the building, then they're going to need to elevate. And so I've seen people who have started repairs and then they get a substantial damage letter sometime after. A lot of those repairs have to get undone, and that's not going to be covered because the policy is just paying for indemnification. So having a game plan up front is very important. The rest is about increased costs of compliance. R wasn't renovation, it was relocation. Knew I was off. We call this our friend Fred, floodproofing, relocation, elevation, and demolition. The policy pays up to $30,000 for those activities, and those are the only improvements that are paid under the policy if the eligibility for them are met. Policyholders shouldn't be required to sign anything. We directed for Harvey, Irma, and Maria payments to be issued based on the examiner review of an adjuster's report, final report, just based on that alone, without requiring the policyholder to sign the final report or to sign like a proof of loss form or other form by the carrier or by the adjuster. So that really shouldn't be an issue. When it does come to an issue is, we'll talk about a proof of loss requirement that's coming up. Actually, so it's on the slide, second bullet. Proof of loss is basically you're in a dispute with your insurer. And we're getting to a one-year deadline. I mean, we're not now, but when you're getting to that one-year deadline, I'm looking maybe 7, 8 months out. That's when we're starting to hit a red zone for deadlines, and you haven't been able to resolve it with your insurer. To preserve your rights as a policyholder, you need to submit something called a proof of loss. Proof of loss is outlined on here. It includes forms, and it includes all the supporting documentation that speaks to the coverage and value of your loss. The proof of loss deadline normally is 60 days under the policy. By default, FEMA extended it to 1 year, 365 days after the date of loss. For Harvey, Irma, Maria, and those bulletins are cited here. Timely and compliant proof of loss, including supporting documentation, is required to preserve your rights before the carrier outside of court, and it is a condition precedent to actually filing a federal lawsuit. And I'll kick it back to Chris.
Okay, so when it comes down to it, at the end of your flood insurance journey, if you will, you're either going to have one of two outcomes. You're either going to get paid for everything you asked for, or your insurer is going to deny all or part of your claim. And when they do that, by law, you're allowed to file an appeal. And myself and about 5 other folks work together to deal with all the flood insurance appeals across the country. We want to make sure that policyholders have the voice to have the chance to voice their concerns. We want to make the program as transparent as possible, and so we've created a non-adversarial process by which we will take a second look at things, and if the answer was wrong the first time around, we can direct the companies to make payments and provide satisfaction to the policyholder. So the things that you need to know to file an appeal. The first thing we need is a copy of the denial letter. This is your ticket to appeal. Folks think that we have push-button access to the claim file, a room full of people on headsets with, looking at your house in real time with a drone or something. That's not happening. There's a number of us that are working with the companies, requesting the claim files, requesting any other documentation, requesting them to do a write-up. Sometimes we have to talk to the adjuster that was on the scene, and so it's a labor-intensive process. But what we need to know is that you were actually denied, because starting those wheels in motion, if you haven't been denied yet, means that we're interfering in a live claim, and we don't want to be second-guessing the work that's actively going on in that customer relationship between the company and the policyholder. We need a written basis for the appeal. We've seen we don't have a form currently, so we've seen the gamut of "I disagree" written on the denial letter, all the way through to small novellas about the history of the home and the flood insurance claim that happened. And then, the other thing we need is any other documentation that actually supports the appeal. Contractors' estimates, any kind of receipts or checks that have been cashed, or anything else that shows what you've incurred and why your claim should be supported under the policy. The letter has to be the appeal has to be filed within 60 days of the date of the denial letter. We have an email option now. It's on our webpage. So if you go to the link here, you'll be able to see our email address. We've also directed all the carriers, when they deny the claim, to include a policyholder rights document that tells you how to actually go about filing your appeal. So that way, there shouldn't be any question. When people get that letter, they'll know they're denied, and they'll know what their options are to take further action. If they want to have somebody represent them, they need to make sure that they're complying with the Privacy Act. We don't get out of that requirement, so the regulations that we have to carry out for that are 6 CFR 5.21, but we have it all spelled out on our website, so if you just go there, you'll get a nice little cheat sheet. So we have a number of do's and one don't. Again, make sure you've been denied. We can't do anything that's in process. Also, if you filed suit against your insurer, then we have to end the appeal the moment we get it, or the moment that we learn that litigation has been initiated. Again, we do need documentation that supports the appeal. Somebody just going, I don't like this, doesn't help us. We need to find out what was it you think. Did they miss a room? Did they take poor documentation? Has your contractor come back with wildly different numbers? What's the issue that you're trying to seek our help with? And then the last thing, and this one's the most crucial part in this slide, is do continue to cooperate with the adjuster and the flood insurance company. A lot of times during our process, because it is non-adversarial, we'll say, hey, could you send somebody out there to do an elevation study or to look at this room again, and then the policyholder calls us up and says, somebody came by my house and I didn't want to let them in. Well, please let them in because we asked them to go there. So that's one of those things where the more cooperation that you can have between your clients as policyholders and the folks on the flood insurance side, the better off the process works. So after you file an appeal, you can still file suit if you're within the statute of limitations. You're able to file in the district court where the event happened. It must be within 1 year that the claim was first denied in whole or in part by the flood insurer. So it's not tied to the event; it's tied to the first denial that they received from their insurer. So make sure that you know when that statute that statute of limitations is running from. Otherwise, you might find yourself timed out. And again, because it's a federal program, we're not, other causes of action, extra contractual claims, bad faith or claims for attorney fees, those sorts of things are generally not considered in litigation itself. There are other resources that are available on the flood insurance side. The Office of the Flood Insurance Advocate was stood up a couple of years ago in one of the many acts I cited to at the start of this presentation. They're there to help educate policyholders, and they will step in if there's an issue that somehow slipped through the claims, appeals, and carrier cracks. So they will do some level of investigation to help handhold the policyholder to an extent. They can also answer questions about maps and floodplain management and some of the other grant programs that exist within the National Flood Insurance Program. And then we have a number of links that can help find out who's who in the zoo in terms of the insurance companies, our support call center, other websites that are of use, and at Ben's urging and at my own urging, like we've said, if there are any questions, please do contact us. We want to be here for you. We're trying to make it as collaborative as possible. We, want to see policyholders recover, and we are first in that. We're the first part of that disaster recovery for the survivor / policyholder. Because we don't require a presidential disaster declaration to step in. It's a contract between us and the policyholder. But in those large disaster situations, we have the individual assistance program. So I'm going to turn the program over to Mary Ellen now.
All right, thank you, everybody. I have my contact information up there. Please feel free to contact me. Don't worry, I'm going to delegate it to one of my staff who's a subject matter expert in IA assistance. So, please contact us. And the truth is that if there are issues, if there are groups that are not getting the assistance, or if it appears that somehow, we are not adequately communicating with applicants, we want to know, and we want to take care of it as quickly as possible. And that's one thing about the FEMA Stafford Act disaster assistance programs is, we're very nimble, And so if there are processing issues that are causing delays or problems for applicants, we want to know about that so that we can course correct if possible. So that is important to us. So what I'm going to do is kind of go over basically an overview of disaster assistance. And FEMA implements the Stafford Act, which provides disaster assistance when there's a federally declared major disaster or an emergency. Generally, individual assistance, which is assistance for individuals, may be provided for a major disaster declaration and is very rare for an emergency declaration. Our regulations are found at 44 CFR Part 206, primarily from sections 101 to .191. Okay, we're going to talk a little bit about the 2017 hurricane season, which was a doozy. What I've posted up there is the information for the disaster declarations for Harvey, Irma, and Maria. And this was the first time that we had 3 Category 4 hurricanes hit the U.S. or its territories ever. So to have those 3 landfalls at Category 4 was extraordinary, and in such a short time period. So we were, not catching our breath, and it's certainly very devastating for the folks, and it really appears that it was the last one, Maria, which was the hardest in the way that it has affected the U.S. Virgin Islands and Puerto Rico. So if you're assisting an applicant who has applied for assistance, you can quickly get information on the disaster through FEMA.gov. And again, we've got the websites there, and it'll help you know, for example, what's the declaration date, because that will trigger this. Generally, we provide 60 days to register. Many times, though, if areas are added after the initial declaration, we may extend the time period, but it's a good rule of thumb that, look to the declaration date for when individual assistance was provided to see, that you've got 60 days to apply. Now, there are, certainly the state or the tribe can ask for an extension. And in addition to that, we allow, if someone can provide good cause as to why they were unable to apply within the deadline, we'll accept that. So, again, these hurricanes have broken incredible records. So we had approximately 12,000 employees deployed. That is double the amount that we had for Sandy, which was probably the largest number we'd had prior to this current season. We had peak daily registration of over 173,000 registrations in a day. And we've had a total of 4.5 million registrations. And this is, the Harvey, Irma, Maria, and also the California wildfires. So, and we have to date provided $2.5 billion in assistance for individual assistance applicants. There's going to be a lot more provided. When we have conducted 1.5 million inspections to assess disaster damages. There are approximately about 60,000 appeals at this point. And there's actually been, and you may have heard or read in the paper in the news that there's been some fraud, some identity theft cases. So folks have actually gone to apply and found out that there's already an application in their name. Or they have received a letter saying, from the SBA saying, sending them a packet of information, because when they apply for FEMA IA assistance, individual assistance, they're then automatically sent information from the SBA, and they're like, I never applied. So if you have a client who's saying, I got this letter and I never applied, or I tried to apply and they said that there's already an application in my name and for my address, then I would urge you to go to FEMA.gov and put in the search term disaster fraud, and that'll show some kind of information there. We have put in some verification controls, and so that if an application looks suspect, to kind of try to help and see, and the processing for those cases then goes to a more experienced case manager at our National Processing Service Centers. So this is something that we really hadn't seen in the past, but it's not surprising considering all the identity theft occurrences that have happened. And so it appears to be something that's occurring more with online registrations. So just something for you to note. Okay, individual assistance. So when individual assistance is designated for a major disaster or for an emergency in the rare occurrence, then certain types of assistance under the Stafford Act are available. And those are for designated areas. So you have designated programs and you have designated areas. And this can be for a state or for a tribe. We define state to include the U.S. territories. So that includes the Virgin Islands, Puerto Rico, Guam, American Samoa, and the Marshall, and the Commonwealth of the Northern Mariana Islands. So IA includes the Federal Assistance to Individuals and Households program, which we call IHP, and that is our signature program, is IHP. And the regs for that are at 44 CFR 206-110 to 120. Please do not refer to 44 CFR 206-101 or 206-131. Those are for a prior iteration of the program. They're still on our books, but you don't use them. We also have disaster unemployment, which is administered by the Department of Labor. Then there's the benefits and distribution, or the disaster, the DSNAP program for supplemental nutritional assistance. We have food commodities. We have disaster legal services, crisis counseling, transportation assistance to individuals and households. That's a rare program, but it's actually being used for Puerto Rico, where we provide assistance so that folks can basically get off island. We have disaster case management, and we also have what's called the Cora Brown Fund. I put there the websites for the individual assistance fact sheets, which can give some good summaries of the particular programs. And also there is the website for disasterassistance.gov, which is kind of a one-stop shop for finding out about the various disaster programs. Now, in addition to our IA programs, we also have some mass care services programs, which applicants don't directly apply for them. They're actually provided to the local government or to the state, which has the responsibility to ensure sheltering for its residents. And so we have what's called the Transitional Sheltering Assistance, or TSA program, when we will pay for hotels for disaster survivors. So it's kind of, it's to help them, it's non-congregate sheltering, because being in a congregate shelter is untenable for more than a few days. And so we, have set up this program so that folks can go into hotels. We also have a program to basically make emergency repairs to people's homes so that they can actually shelter in place. So these are rudimentary type repairs, and it's only so that they are not forced into a congregate shelter or, so just to allow them, again, to shelter in place. And we also have what's called the Blue Roof Program, where we may provide tarps or kind of blue sheeting to temporarily repair roofs so that people can, again, shelter in place. Those programs are not under the umbrella of individual assistance or the individual households program, so they don't count against the caps, the financial caps that are set up for our individual and households program. So that's important. So again, IHP is our primary IA program. We have unified guidance that was published a year ago that lays out the the processing and general eligibility criteria. So if you are assisting someone who has issues with their IHP claim, I would recommend that you download what we call the IPUG. Now, you may also want to contact FEMA to see if there's any additional guidance, because for the current slate of events, because of simply the magnitude, FEMA has loosened up some of its processing requirements. And so you may want to, verify what's actually required for your client. Okay, IHP consists of really two major components. It's housing assistance and other needs assistance. The housing assistance can be either temporary, where we can either provide by financial assistance or direct assistance, temporary housing. So we may give you money so you can go rent an apartment, or we may provide you with a mobile home or with an apartment. While the disaster survivor is establishing their permanent housing plan. How are they going to repair their home, or are they going to relocate and such. We also have repair and replacement, it's financial assistance. And we have our permanent housing construction program, which can be financial or direct. The second basic program under IHP is our other needs assistance, ONA, and it's financial assistance, and it may be administered by FEMA or by the state or the tribe. And it can provide for medical, dental, child care, and funeral expenses, personal property, transportation, and other serious needs. Now, financial assistance is capped at $33,300 per applicant per declaration for the fiscal year 2017. So for the Harvey, Irma, and Maria applicants, the maximum amount of financial assistance they can receive under IHP is $33,300. For the California wildfires, because it occurred in fiscal year 18, their maximum is $34,000. So there is no statutory cap for direct assistance under these programs. So that's an important factor. And applicants may be eligible for a blend of assistance. So they may get, for example, some direct temporary housing. Maybe we place a mobile home on their property, while we also give them financial assistance for to make repairs to their damaged pre-disaster dwelling. And then they may have some other needs assistance requirements, and we might also provide assistance there. So, but for the financial, it all has to, it can't go over the statutory caps. For permanent housing construction is been rarely used in the past. We had used it in American Samoa, in Alaska, and for the Oglala Sioux Reservation. We have authorized it for Texas, and I believe we'll be authorizing it for other of the jurisdictions that have been hit by these hurricanes. And so the assistance that will be provided there will be direct assistance, and it will be to actually make major repairs to people's homes so that they can get back into them quickly.
We have just a few seconds left.
Okay. Just very quickly, the general eligibility criteria. You have to be a U.S. citizen, non-citizen, national, qualified alien. Any eligible member of the household can qualify the household. So that can be an infant, can qualify the household for this assistance. It's got to be necessary expenses and serious needs that are directly related to the disaster. And these have to be unmet needs. So if, insurance is covering the need, then we will not. Again, registration, phone, smart app, online, very important. We do identity verification. The applicant has to sign the declaration and release form where they affirm that they're a citizen, non-citizen, national, or qualified alien. We also need to do an occupancy verification and property ownership verification, and check out for their insurance. So the main reasons for appeals are the applicant has insurance that we believe should cover their loss. FEMA is unable to verify the applicant's identity. There's insufficient damage to the property. The applicant is withdrawn voluntarily, or more than one member of a household has applied. So those are the primary reasons that we do get appeals. Our records are Privacy Act protected, and so we will need a release in order to provide information to you as their advocate. And I always want to stress to folks that when an applicant signs the declaration of release form that they're a citizen, non-citizen, national, or qualified alien, we don't request any other information as to what subcategory of qualified alien they are, for example, or require proof of their citizenship or their immigration status. What we ask for is identity verification that they are who they say they are. We do not collect any information about the status of anyone else in the household. So we simply don't maintain those kind of records. We don't need them because we just needed the one eligible applicant to qualify the household. So we have national processing service centers that will process the applications and will provide information on the award letters on the appeal process. So I think I probably beyond my time, right?
Is there anything important that you still need to?
I would say that you want to, if you can, talk with the caseworker about the case in which if you're helping with an appeal, because it might very well be that's and that you get a copy of the file to see what's been written in there and see if there's there's a miscommunication, because that can very well be what happened. And so, you know, they have in their notes that applicant said X, and so now that's their X. They said X, and because they said X, they're not eligible. So you just want to know that you have the file so that you can clear up any concerns and provide whatever missing documentation has been noted. And again, please feel free to contact me, and we'll assist as best we can to get you. If you had difficulty getting the records or getting any responses, we're happy to find out what's going on in the case. We have sometimes we actually have to ask for money back. And so we have a detailed process for that, the recoupment process. And in the IHP, the IPUG, you will find this process chart laying out how we go about trying to get money back. We hate doing this. We absolutely hate having to do this, but legally we're required to. And so, but we do have a process for it, and it's important that you become familiar with it and see where it is with the potentials for hardship waivers and such for applicants. Thank you.
Thank you. And I apologize to all three of you that we had to have you put so much information in such a short period of time. We now get a chance to listen to Will Friedman, who is with the New York Legal Assistance Group, NILAG for short, which was one of the leading not-for-profit agencies representing people after Sandy hit the Northeast. So, Will.
And here we are. So, hello everyone, thank you, and definitely thank you for your interest in doing some of the volunteer work related to this. It's a tremendous amount of need, it's very rewarding, and I'm excited that there is such a huge amount of interest time and time again. So to get started, I'm going to go over a few things. We're basically going to focus less on the rules, as have been gone over by our friends at FEMA, and we'll be looking a lot more at the advocate's perspective. So when we get hit with one of these issues, when our clients have a particular problem, what is it that we can and should be doing and thinking about? So we'll go over a review of the process, again, from the advocate's perspective. I'll go over some of the common reasons for denials and some of the ways that we found effective in terms of challenging those. The list correlates quite strongly to the list of the common denials. We'll talk very briefly about recoupments if we have a little bit of time and some of the other issues that can tie in here. And then I have a list of some general tips that we found helpful if you're preparing to do this type of advocacy work, things to keep in mind to ideally help the process move along. But before we get there, just very briefly, as Tom gave me the introduction, we don't have to dwell on this a little bit, but the New York Legal Assistance Group has been pretty heavily involved with these issues for quite a long time. We're still active in terms of helping people with the still lingering issues coming out from Sandy. We've worked on about 13,000 legal matters. We've helped clients get approximately $59 million in benefits over the years. And we've worked on a laundry list of issues, including, of course, FEMA. So FEMA denials, of course, can happen. I do like to think that the FEMA representatives that we deal with are genuinely interested in helping. You know, I've dealt with many government agencies over the years. Some of them are better than others, and I'm generally quite happy with my colleagues here at FEMA in terms of their dedication to actually trying to help. But that being said, not every issue do we see eye to eye on. And in terms of if there is a denial, you do generally have appeal rights. There is a specific list under the regs of what you can appeal, and this list does realistically cover pretty much everything that's going to come up. And the highlight here is the first one on the list, the denial of eligibility for benefits. So that's really what we're thinking about here. So just very briefly, procedurally, since we didn't quite cover this, I don't think, the decision letter, which ideally will be an approval, but sometimes not, generally comes out in about 30 days after the application. I think the timeline can vary a bit, especially on how quickly the inspections take place and such. But generally speaking, it comes out fairly quickly. You know, this is emergency situations that FEMA gets involved in, so not surprisingly and thankfully, they do move pretty quickly in our experience. The notices that get sent out, one quibble I do have with my FEMA colleagues is they are not the clearest in my opinion. They do list that a denial is happening, they'll list some codes, but it's not a very giant laundry list and pages of explanation about all the problems. That being said, once a notice is received, you can certainly call up FEMA and discuss. There is generally a code listed on the letters, which will tell you, it will correspond, and I have a link here in the PowerPoint of what those codes are, so you can translate that to help you guide the conversation. When having advocacy with FEMA, I have my 5 steps here, which I think is fairly comprehensive. So step 1, the client comes in, they have their issues. Disaster victims, when they come to meet with you, often don't have every piece of paper that they perhaps should, but they should at least have some information, including ideally the denial letter. So the first step is, of course, to go over the situation with the client, get their perspective of what's happening, to review whatever documents you can. If the client signed up online through disaster.gov, there's certain additional information you can pull from the online account, some of the auto-generated letters and such. So it's definitely helpful. And if you're dealing with people earlier in the process in terms of helping applications, I definitely, to the extent the client is comfortable with it, encourage people to sign up online as opposed to over the phone or going through one of the centers, just because, again, you can access some information which can be very helpful. I have a note here to take note of any applicable deadlines. You know, as lawyers, we should know deadlines are important, but thought it was good to highlight that. So step 2, give FEMA a call. FEMA has their call lines open. You can always reach them. And there are, quite shockingly compared to dealing with many other agencies, a lot of issues that can be resolved over the phone. As long as you have a handle on what's happening, if you pick up the phone, talk to the FEMA representative, there are things that can be worked out and fixed. And as, again, my FEMA colleagues here have generously volunteered to take calls and issues. So if you do see things, you should definitely feel free to reach out. The FEMA legal people we've dealt with in the past have been very accommodating in terms of fielding our questions and trying to help us along. One thing I do want to note, though, in terms of the general call centers for FEMA, FEMA will bulk up when a disaster happens, and additional staff will be added to man the phone lines. Sometimes when you call someone at FEMA, they are very helpful. Sometimes when you call someone from FEMA, they are less than helpful and perhaps are not quite fully understanding what the rules are. So what we have found, and this is probably the most important point I have of the day, so write this down, is hang up and call again. If you get a FEMA representative who does not know what's going on, is hostile, is difficult, is refusing to talk to you, instead of fighting them endlessly over, you know, your right as the attorney to speak with them, you sent in the release forms, et cetera, just hang up, call back. There's a 0.01% chance you'll get the same person. At the end of the day, either someone is eligible or they're not eligible. So I'm not suggesting keep calling until you find someone on the other side who's too accommodating and, you know, rubber stamps your application, because that'll just lead to a recoupment down the road. So again, the idea here is just if you're getting someone who is really uncooperative and seemingly not understanding the actual rules, just try again. So once you get there, if there are still issues, you want to obtain the FEMA file. The reason I have this down the list a little bit is just because it's not the fastest process in the world to get the file. You send the request in. You know, obviously FEMA really kicks into gear when a disaster happens, which means there are thousands and thousands of people having claims. There are probably hundreds and hundreds, if not thousands and thousands of people asking for files. They have to do a Privacy Act review of these files, which means they actually have to look through these and perhaps redact documents. So it can take some time to actually get the file. So sometimes you can just hammer through things quickly. It's very obvious. But frequently you do need the file. You probably want to start asking for the file sooner, just to get the ball rolling on it. But once you have the file, again, you want to review, see what's going on. One particular useful thing to highlight is what's called the mailroom notes, which basically anytime anybody calls in, notes are taken about what the conversation was and what's happening. So again, this was referenced by my colleagues here at FEMA. A lot of times it's the client called and they said X, and X was probably not a good thing for them to say. Maybe it's really just preventing them from being eligible, but sometimes they just didn't understand the question or something along those lines. We had this come up a lot with, and we'll get into this a little more later, people who have to certify the fact that they have ongoing need. So we had one person where they asked, the FEMA rep asked, have you gone back to the property? And the person said yes, because they go back all the time to monitor the construction. And the FEMA rep took that to mean, yes, I moved back in and therefore I don't need temporary rent anymore. So there can be little things like that, and the mailroom notes can kind of show what the actual issue is. So again, once you have the file, step 4, contact again, see if you can work things out. And again, there are plenty of occasions where you can. And then finally, the last resort is to do an actual written appeal, which we'll get into in a few minutes. So one thing to note about the file request, it has to be very specific. One issue we did have back in the days of Sandy was FEMA representatives being unwilling to accept the releases that were the client representatives or the file request. So very important to have all of the necessary information and avoid the potential for any issues here. So I think the slide here is comprehensive on everything we've needed to show to get the actual files released to us. Very important, the declaration of penalty of perjury language. If that's missing, that is generally a problem. So again, you can refer to this slide, and this information should be circulated. So let's say we have problems. We get to the point where we have to actually submit a written appeal. The appeal needs to include certain things. Number one, if you're submitting the appeal for that person, you should have a letter in there explaining who you are and that you're the representative, and again, having that important information about what the representation agreement should include. We often have this initially, we'll request the file first, so it'll be in the file already, but you know, don't tempt fate, just submit it again. You know, you don't want to be in that situation where something gets rejected because it's missing a page where you could have just easily put it in. Number two, you need an actual affidavit from the client or something notarized with a sworn statement where the applicant is giving their specific facts. You know, again, similar to any sort of court action, it's not enough for us as attorneys. We don't necessarily have personal knowledge, so you need something from the actual client explaining what the actual facts are. Then there'll be something from you, further going into the issues, a brief, I suppose, where you will explain what's going on and why the decision should be overturned and there should be eligibility. And of course, you want to include all the supporting evidence. And this is, I think, in addition to maybe not properly explaining the points if clients do their own appeals. The including documentation is often the problem. The clients have probably sent these documents in 1,000 times, and maybe they were misfiled, or maybe they sent it to the wrong fax number, or maybe they're confused and they sent it to a charity group, and this group and the insurance adjuster and everybody else. Clients are very frustrated over the fact that documents don't always go into the right file at the end of the day. But when we're doing something, and it is similar if you're doing a motion in court, you want to have all those documents. You don't want to lose on a stupid technicality that you didn't include the pleadings in your summary judgment motion. So just, waste the paper, print out the extra page, again, showing those receipts. You want to have all the supporting documents. Anything you're relying on needs to be in there. The best tip that I have in terms of these appeals, when we were doing these and we were focusing on really legalistic approaches and, this FEMA notice is offending due process and it's not clear enough, those did not go well. Those did generally not lead to anything successful. The appeals that we did that were most successful really focused on the factual situations, getting to the meat of what's happening here and why this is a correct avenue for someone to get FEMA assistance. You should think of the target audience, and I'm not sure if the actual reviewers are non-lawyers or not, but we definitely found if we targeted these at like a non-lawyer level for the person reviewing, we had much, much better results. That being said, you don't want to waive your legal arguments. You can certainly throw them in here. You don't want to waive your due process claims and all of that. But the focus should really be on this is what's happening. It's clear that this is someone who should be eligible for FEMA. So with that being said, let's look in some detail about some of the common issues, and this overlaps pretty heavily, although I think one or two is maybe different. This is in terms of what we've seen over the years, and part of things is sometimes it's just the luck of the draw of what clients come in. But this list here, I think, is a good sampling of the types of issues that people will have. Not exhaustive, of course, but fairly comprehensive. So number one, issues with residency and ownership, issues with household composition, issues with complicated or non-traditional households. This is one of the bigger ones, and I think one of the ones where attorneys can have the most impact. There's FEMA noncompliance, which is probably something that won't come up too much, particularly with Texas and Harvey, but I do want to touch on that because it's fairly important. The issue of storm damage, whether a property actually received storm damage, which was on the list there, whether there's actual need for assistance, whether there is truly unmet need here, and just as a subnote of that, whether there's ongoing need for certain things that get recertified. And finally, a couple of notes about people who have insurance coverage already. So these ownership issues come up surprisingly often. So FEMA assistance is available only if it's the applicant's primary residence. FEMA doesn't want to pay for someone's vacation home. I think that's pretty uncontroversial. Renters can be eligible too, of course. Every once in a while, renters try to claim home repair awards just because they've lived in this house forever. They think it's their property, but if they don't own the house, they don't get home repair. The reason this comes up is in our kind of attorney-privileged lives, we, I think, are generally going to have our driver's license and identification. We're not going to live in a sketchy basement apartment with no lease. But that's not necessarily how the entire world works. Particularly lower-income individuals often don't have great documentation of who they are and where they live. Again, if someone's in an illegal apartment, they probably don't have a written release. They probably pay rent in cash, and the landlord probably doesn't give them a receipt. They probably don't have a driver's license, especially in an area like New York where there's mass transit available. So it can often be difficult to actually establish that somebody lives in a given address. And this also can come up with ownership issues where, again, in sort of the middle class upbringing, if you have a house, your name is on the deed. But there are plenty of people where it was the parents' house, the parents died, and now it's their house, and they never went to surrogate's court and changed over the deed or anything like that. So maybe in sort of, in practice, it's their house, but legally speaking, it's still the parents' house. And that can be, again, another issue. The FEMA definition of primary residence is also a little more restrictive than some other programs that define primary residence. For example, the IRS rule is a little more open. Post-FEMA, when the Build It Back program and New York Rising program came up to New York, their definitions are a little more open than the FEMA definition. But again, this can be potentially a problem. So how do you do something about this? So if somebody comes in, it's perhaps a lower income person, they don't have a lease, or maybe they did and a storm happened and they have all their important documents in the basement and now all of that stuff is gone. It's obviously a difficult situation to deal with. So the best thing to do is to document, document, document. As much as possible, come up with documentation. It's great for the client to have an affidavit to say, yes, I live here, but that's generally speaking not going to be enough. There really needs to be some sort of proof. So you need to think creatively about what is there to actually link that person to that property. Did they get mail there? Can you find an old postmarked letter that's addressed to them there? Do they have bills, again, with that usage address? Utility bills are a particularly great way to show occupancy because assuming the usage patterns are somewhat normal, it really shows that somebody's living there. And that's assuming they're paying their own utilities, though. And the other issue with utilities, the longer it goes on, the harder it is for your utility company to come up with this information. We're going to come back around to this, but the sooner we get involved as advocates, the better, because the more time passes, the harder it becomes to document these things. You know, memories will fade, documents will get harder and harder to track down. So again, the sooner we get in there and we can start thinking about things, the sooner we can pull documents together. The other thing I want to touch on here is the household presumption. I don't know if it's technically a presumption, but that's the way I think of it. If multiple people are applying from the same address, FEMA will assume that everybody's in the same household. And it's up to the applicant to demonstrate that they are in a different household. So if you have a situation with a landlord and there is in the top of the house and they're renting out the basement, if it can sort of be like a race to who applies first. And then there can be complications, even for the person who applied first, there can be complications as to, is it really their address or is it this other person who applied from the same address? We often ran into problems, and I think one of the more common distressing fact patterns with these rental situations, if there's one of these sketchy issues with an illegal apartment, and the government calls up the landlord and says, hey, we got an application that a tenant was living there too. Can you tell us about that? They probably haven't been paying taxes on this. They're going to say no. They're going to say, I have no idea what you're talking about. I've never heard of this person. And that, of course, is a big problem for the applicant. And you have to come up with, again, the creative ways to demonstrate that they actually were living there. We also saw a few pretty interesting cases with non-traditional housing arrangements. So for example, we had a few cases involving domestic violence situations where an individual had fled the property, but technically their name was still on the deed to another property. And so that's an issue where we can try to explain to FEMA, this is what's going on, look, we have these orders of protection, and try to document that this is actually a true situation and this person should be eligible for benefits in this address that they now reside in. So FEMA noncompliance, this is hopefully not going to be something that we encounter, but it's a pretty serious thing, so I think it's worth touching on just for a minute. If there's a flood-related issue and somebody receives FEMA benefits, written in the fine print is the fact that FEMA will help you once with one of these issues, and then you're expected to buy into the system of flood insurance. And flood insurance would then cover you to the extent there is another flood in that area. So this came up a lot from Sandy because we had Hurricane Irene, and Irene hit a fairly similar area to Sandy, although it was much less severe. We had many, many people who got a relatively modest award for Irene, say $2,000 for a boiler or something like that. They didn't notice the fine print that meant they had to get flood insurance. Sandy happened, their house is destroyed, they have $200,000 of damages, but they are considered FEMA non-compliant because they did not buy into the flood insurance system. As a result of that, they are completely ineligible for everything. They can't get FEMA, they can't get other benefits, they can't get anything. So it's a really, really sort of draconian issue here. So hopefully people won't have this problem, but to the extent you are assisting someone with a flood-related issue, you definitely want to talk to them about the fact that this means they get help once, and from then on they need to be buying into the system. So the next issue here is denials due to no storm damage. So when someone does a FEMA application and an inspector comes out, they'll look at the property. Generally speaking, someone will call, Sandy's, for example, was on October 29th. Generally speaking, people were calling FEMA on November 1st or November 2nd, but that's not always the case. And particularly, say, with Puerto Rico, given the big infrastructure problems, the fact that phones and internet is often down there, it's not always possible to get that FEMA inspector in there right away. The more time that passes, I think the more, A, sort of questionable it looks of whether the person has an actual Sandy claim, and two, if wear and tear happens, it can really kind of shade whether this looks like storm damage. So for example, if there's roof damage and then the inspection doesn't happen for a relatively long amount of time, there's water coming down, it's creating water stains, and it's looking like this has been something that's sitting here for a while. We particularly saw this issue with seniors who perhaps were not keeping up their house in fully anyway. So, a slightly non-fully upgraded and upkept house, and then this happens, and then they were perhaps a little slow because they don't have internet access. And then FEMA comes out and says, hey, this looks sort of like deferred maintenance. Like, you're having problems, you never fixed your roof, it's really not a Sandy issue.
I will say that they better not be going out and saying deferred maintenance, so we don't use those terms.
Okay.
No deferred maintenance and no pre-existing conditions.
Okay.
It's not disaster related.
Okay. Yeah, deferred maintenance is the term of art that the Build-A-Back program likes to use. But in any case, if you get one of these cases, again, if you want to challenge, it's all about the documents. What documents do you have to be able to demonstrate that this was actual storm damage? As I think Ben mentioned, it's always good to have pre-storm pictures. Most of us don't go around and take pictures of our house in its normal condition. We really should. The other takeaway advice, go home, take pictures of everything. You should all have a disaster plan. I mean, that's the way it is. You never know. But most people don't. But theoretically, there's probably a birthday at your house, and there's a picture of your TV in the background, or there's pictures of the outside of your house in the background, or whatever else. So there are actual pictures. We had one case, actually, where we were able to use a Google Street View map to show that the house was fine before FEMA, and then there was a tree on it after the storm. So you can actually be a little creative, perhaps, in finding information, but it's really not enough for a client to just say, yes, this absolutely was fine before, and now I had issues. You really need supporting evidence of some kind, and it's not always easy to dig up. Contractors or engineers could perhaps write statements. Ideally, it's more of an engineer issue than a contractor issue, but a statement from an engineer on their letterhead, not just that says that this is hurricane damage, but saying this is hurricane damage because, and explaining the reasoning, can have some positive effect. One other issue to look at, sort of similar, is denial for lack of any sort of unmet need. FEMA is intended to be a last resort program. It's not for luxury items. It's not for things like that. So ultimately, you have to demonstrate that there is an actual need. So if you're affected by the storm, but the only damage is your satellite TV system was knocked out, FEMA's not going to be interested in that. So there has to be an actual level of need that connects to basically the safety, being able to safely and live in a sanitary environment is the way I think about it. So a couple of common issues that come up are, one, the level of repairs. We get a lot of people who come in and say, FEMA's only giving me $10,000, but I have all these things wrong. And sometimes there is a legitimate issue there and the inspector missed something, and sometimes it's that their granite countertops were cracked. And again, that's not something that FEMA is going to get involved in. So you need to think, really, is this an issue of actual need, or is this a luxury? The other time we see this a lot was with vehicles. The general rule is one vehicle per household, but there is the ability to advocate to have a second vehicle. So at least in the days of Sandy, we had a lot of pushback for clients who were trying to get assistance to replace a second vehicle. But it is possible to be challenged, but it has to be documented that this is an actual need and not just a luxury. It's great to have two cars. It's certainly very convenient. Maybe in New York City with mass transit, maybe it's less necessary. But in general, if it's a two-adult household, two cars is probably the norm in America. But it's not really a necessity, per se, unless you can document what is the real need for this. Does one person have to work 100 miles east of the house and the other person 100 miles west? And it's just impossible for them to operate with one car? Is there some medical issue where somebody has to be going back and forth to the hospital or doctor's appointments, things like that. So this is something you can challenge, but you really need to be, again, creative in what is it really that is the need here, or is it just it's more convenient? And just the last point on this is with ongoing assistance. If somebody's getting rental assistance, it's not just forever. There has to be occasional recertifications to continue to receive rental assistance. So this is another thing we saw quite a bit of. People got their initial rent assistance and then they were threatened to be cut off from the rental assistance. So again, in order to get rental assistance in a temporary rental, you need to be able to demonstrate you need the temporary rental. So we often saw this come up in situations where the client identified, say, a mold infestation in the apartment that would make people sick if they moved back. But the FEMA inspectors did not pick that up and did not identify that there's still a potential health issue for people to move back. Again, it all comes down to what can you document. Mold is always a tricky thing. If anyone has ever dealt with mold-related issues with housing cases, it's a tricky thing to try to establish and prove. But it is something that progress can be made on as long as you can document what the problem is and why there is a continuing need. We see these come up occasionally too, where FEMA finds out that this person could have lived for free in some other area, something like that. Sometimes, yeah, they could have lived there for free, but sometimes that property was not available for some reason. So again, all these things will have to be fully documented. Last thing on the list here is denial due to insurance coverage. Again, FEMA wants to be the last resort. If you are getting insurance money, FEMA will, with some exceptions, not be assisting. That being said, even though FEMA will deny once somebody says, yes, I have insurance, the insurance companies work and make money by not actually paying out claims at the end of the day. So just because somebody has insurance doesn't mean they're going to be getting full recovery for what's happening. So it is possible to go back to FEMA and say, yes, I have homeowners insurance. However, there's a delay, or yes, they did pay me, but despite the fact that my house is destroyed, I got $1,000. So if something like that happens, the applicant can go back to FEMA and say, this is still going on, this is still happening, you should give me money. However, very important, there's something called duplication of benefits, very important concept which we don't have a lot of time for. I think we're hitting the end. But the idea is, again, if they get the insurance money, they can't also get the FEMA money for the same thing. So to the extent someone is going back to FEMA and asking for FEMA benefits, even though they have insurance coverage, they should think of it as a loan and not a grant. It's just something to tide them over until the insurance money comes through. Once they get that insurance payment that's being stalled out, that FEMA money is, generally speaking, going to be due back to FEMA. Which brings us to the idea of recoupments, which we'll, again, just touch on very briefly. This is not something we're going to see any day now, I don't think. In terms of Sandy, we first started seeing, outside of a few isolated early cases, the first big wave of these that we saw was in September of 2014, so just about 2 years post-Sandy. So again, not something we're likely to see for the victims of Harvey, Irma, and Maria in the next week or two. But it's something we should think about in giving advice. You want to think about the future and not create additional problems for clients going forward. FEMA, as was mentioned, has the duty to look at these claims, and I think particularly because FEMA moves pretty quickly, they give out money pretty quickly, so it is pretty important that they go back and look and make sure that everything was done correctly. That being said, just because FEMA is recouping doesn't mean that the recoupment decision is correct. It is something that can be challenged. But that being said, if there is a really kind of borderline eligibility issue and you push and you get someone benefits, it's still possible to have a recoupment come back around. We have had cases where we had fully processed appeals that we won, and then 2 years later we got recoupment notices for those. So it's definitely something, and clients are not going to want to hear this, but they need to think about the fact that FEMA will still be around looking at these claims. And particularly since we had back-to-back-to-back major disasters, it might be particularly long in getting around to auditing these things. So years from now, FEMA can look around. So just the main important thing I want to stress here is to keep the documentation. People get through this, they think they're done, they throw everything out. It's not a good idea. They should hold on to everything. And also, one issue for recoupment is potentially if the funds were not spent on the right things. The FEMA award letters can often lag behind the direct deposit payments. So oftentimes people get something direct deposited, they think this is great, I have my money, I can pay this rent where I'm about to be evicted from this temporary apartment. And then the letter comes along and says this is to fix your roof or your boiler or what have you. At the end of the day, that person needs to be able to establish if the FEMA money went to X, they need to be able to show it was spent on X. It doesn't really matter if they had other true legitimate need. Ultimately, the FEMA money gets tied to whatever the FEMA money was awarded for. So very important to let clients know to wait for that actual award letter to see what the money is for and to keep their receipts so they can document if FEMA comes back around and says, hey, by the way, we want to make sure you fixed the roof that you were supposed to fix, that they can show that they actually did. So we have a list here, which I don't think I have a lot of time for. And this mirrors pretty closely the appeal denial list anyway. Really the only new thing here would be, again, the last item on the list here, misspent or fraudulently obtained funds. I do want to say with fraudulently obtained funds, this is pretty significant. If something is obtained by fraud, obviously there can be potential criminal issues. It also heavily affects the ability to waive the debt, to declare bankruptcy, and all sorts of things. So a lot of times things are, I like to think anyway, really not fraud, but misunderstandings where people did not quite understand the rules, or maybe they called up FEMA and were told, oh, this is totally fine, you can get this money, even though they really weren't eligible. So it is really important if you ever see a case where it's tied to fraud, it is possible to try to at least change the finding to mistake instead of fraud. And again, that is significant because that can let the person get a repayment plan or a compromise. Fraudulently obtained funds don't go away in a bankruptcy, whereas other debts could. So, but again, this is not something to worry about this week anyway. So there are some other issues that can tie into, clients often don't have one problem if they're affected by a disaster, especially any lower income individuals or even middle income individuals who were getting by, but this big disaster happened, and even if FEMA is coming in and is trying to help them out, it doesn't necessarily get them back 100% to where they were. So there can be all sorts of other things that connect. I think I'm kind of out of time to go over this list, however. But there is a list here of common issues that could come up, particularly housing related. And I do just want to highlight that whenever a disaster happens, the construction industry, their eyes turn into little dollar signs and they see all the money that they can be making from this. So you really want to warn clients to be careful when dealing with contractors and to make sure things are in writing, to document what's happening, because we've seen just endless issues of unscrupulous contractors trying to take advantage of people. So for my last point, just a few of the advocacy tips that I've picked up over the years, which will hopefully be helpful in your dealings with FEMA. Number one, have the client sign the necessary releases early on, especially post-disaster. You know, we're not quite in the week after these disasters, but it's still pretty close. Transportation can be a problem. If you ever are dealing with someone remote in Puerto Rico, there are all sorts of issues of blackouts and the internet going down. So getting things signed now when you can is really important, because you don't want to lose contact with someone and delay the case for 4 months because you need them to sign that release to pull their file. Again, file requests take a long time, so if there's ever even a remote inkling that you have that getting the file would be useful, I'd just send it out. You know, worst case scenario, you're going to get a big thing that you'll have to scan in, but you don't want to wait months and then do it and then wait more months to actually get it, as that can be a big issue. As I mentioned, try calling. A lot of things can be resolved on the phone. The FEMA people do really genuinely seem to want to try to help people. So don't be afraid to pick up the phone and call. And again, don't be afraid to hang up and call again. The appeals that you write should be clear, easy to follow. Again, I would suggest thinking it as a non-lawyer target. Again, you don't want to waive arguments, but think of this as not targeting a legal audience when writing these. Again, that was our experience. Oh, and a couple of things. If a deadline is missed, FEMA, it can vary a little bit depending on the specific deadline, but FEMA is frequently, at least they were, hopefully still are, somewhat lenient as long as someone has an excuse for why a deadline was missed. So there's a specific clock for appealing a decision. I kind of think of this as a default judgment in New York anyway. You want like the meritorious defense, you want a reasonable excuse, and if you're able to document those, they've been pretty good in actually reading late responses. You don't want to purposely miss deadlines, obviously, but if a client comes in and it's 61 days as opposed to, and their clock has run, I wouldn't just turn them away. I think it's worth still looking at. The general rule was they would look at 3 appeals. However, we found that FEMA would look at more, at least that was true a few years ago. Again, you can't just submit the same thing and bang your head against the wall with the same argument over and over, but if you have new information, if you have new documents, it's worth a try to send something else in, especially if the client, before they got an attorney, kept sending in appeals and they weren't particularly productive. Again, be mindful of recoupments. You want to have a little bit of an eye on the future. One important note, these clients that you would be dealing with, they were victims of a significant trauma. So it's not the same necessarily as dealing with the average client. Disaster victims went through a lot, some of them more than others. But we often have people with PTSD issues, with mental health issues that have spawned out of what happened. So simple things like just getting them to send you that rent receipt can be difficult because they have all these issues going on. They had a traumatic event, they have all these resulting problems, and now they're falling behind in their mortgage and this and that. So just be patient, be empathetic. Remember, these are people who really need help. They can make it difficult sometimes, but they really do need our help. And finally, the sooner we get involved as lawyers, the better, and this was referenced by my FEMA colleagues as well. There are a lot of things that can be set up very nicely for clients if a lawyer gets involved quickly, but a client can dig all sorts of holes for themselves if they don't act promptly. They can cause all sorts of problems of not having documents and making cash deals with contractors and all sorts of issues. So the sooner we get involved and can set people on the right path, the better the final results should be anyway. So that is everything for me. So I'll turn it over back to Tom.
So while Lynn is coming up to talk about the pro bono, I'm going to ask the panel if they have anything else substantive that they'd like to add. Any of you guys? No? Does anyone have any substantive questions before we talk about volunteer? Could you please come up to the mic up front here?
Hi, thank you. Can you talk about translation services in Puerto Rico? Are there any available? How does that work?
I'm not quite sure. My understanding is that when we're talking with applicants on the helpline, we do have a significant number of bilingual staff. And at least in the past, we used to use the like AT&T language services also.
Other questions? Yes, please come to the mic. If you're going to ask a question, please already get up to the mic so we can save some time. Okay. Okay.
Yes, I'm actually from Puerto Rico, so I have a lot of family and friends back there. There's a lot of people posting pictures of like floods that keep happening because of like rain showers that keep crossing the island. How does the constant like flooding and reflooding of property affect a FEMA claim? Is it possible to determine like what was or what will be covered as like Hurricane Maria and what is going to not be covered because it was product of like the consequent rain showers that happened? Because I know there's a lot of like public works, like the drains are clogged and they haven't been unclogged. So how does that kind of get evaluated?
Well, for individual applicants, depending on when they initially apply, they're going to either be processed under Irma or Maria. So that's kind of a date issue. And then generally, the inspector will go out and will assess the damages at the time. So, you know, at the date that they go and assess damages. Now, and I haven't actually looked to see what the incident periods are. So an incident period is established for an event. So a hurricane may be for, you know, beginning X date and continuing, and then at some point it's closed. So the damages have to relate back to that incident. There will be difficulties, clearly, in trying to assess. And so I would say that if there are certain consequences, once the roof is blown off, then, you know, until it's fixed, there's going to be continuous issues. And There are some issues won't even manifest themselves initially. So, you know, the mold, for example, may not occur until sometime in, but it is, in fact, related to the disaster. So I would suggest that the person call back to, you know, see about updating their files and if they have, you know, additional needs to advise.
Thank you. Oh, Lynn Kelly is the director of the City Bar Justice Center, and she's going to start to talk with you about volunteer opportunities.
Great. This will be very by Jennifer Cowan and Jordan Dressler also. So in terms of availability of opportunities for New York, there is a piece of paper back in your materials, and got the materials electronically. If you didn't get them, let us know. Everyone for the excellent training. So right now we are going to be doing, is this not on? Okay, sorry. I have a loud voice, but we're going to be doing clinics on Monday nights at the City Bar during the months of December, January, and February that are specifically targeted to people, attorneys who want to handle FEMA appeals on behalf of anyone who's a victim of a disaster. So we are working on cases coming into that resource, whether they're from Texas, Florida, or from Puerto Rico, or Virgin Islands, or any of the other islands that were affected. I think the first thing to get out to the community is get a copy of your file. So if you're working on any of the other relief efforts, make sure that people are requesting a copy of their file if they have a denial and they want to bring it into one of these clinics. With me tonight is Erica Lawrenson. Erica, can you just wave? Who's our administrative manager. She's going to help set up a Google Docs site, which we will use to book appointments for those clinics. So if you're a City Bar member, you registered tonight, you will get an email from me when we have a pipeline of cases so that we can mobilize people to come in and serve at those clinics. Jennifer's going to talk about some of the other efforts, but there is a piece of paper at the back that sort of summarizes what we know about where people can volunteer and how they can do it right now.
Hi, thank you all for coming. APCO, the Association of Pro Bono Counsel, is a nationwide network of pro bono counsels. So through the pro bono counsel in the localities where the disasters have hit, we have connected with the local legal services organization and really just asked them how we can be most helpful. And as a result of those discussions, they are starting to feed full representations through a listserv set up for pro bono counsel. So if you are at a firm with a pro bono, which has a pro bono counsel, he or she is going to receive those emails, which they're just like any other pro bono case referral. It'll have a little description. If you're interested in taking it, you can do conflicts and follow your own internal approval procedures. It's a little unclear what the volume is going to be. There's probably going to be an ebb and flow, but there are training materials as well as mentorship and expertise at the local legal services organizations to support you. If you take one of those cases and you would like to work on it in a place with other people, you're also welcome to come to the Monday night clinics at the Bar Association and sort of engage in parallel play with other people who are also working on similar matters, and you can bounce ideas off of each other. The nice thing about this one of the nice things about this network is that in addition to those cases, as other opportunities arise, they will also be circulated through ABCO to the firms and from the firms pro bono counsel to the lawyers, and so we'll be able to keep everyone updated as there are more and more opportunities to help.
Thank you. My name is Jordan Dressler. I'm the Civil Justice Coordinator with the City's Office of Civil Justice. I'm not going to take too much time. There's been a lot of discussion of the what of these FEMA appeals and now some of the how as far as people being connected, and you're all tremendous volunteer efforts. I want to say just a couple of words about the who, and particularly about the efforts that we've been engaging in to set up an emergency services center in East Harlem for a variety of city agencies for folks displaced by all of the hurricanes. We've been up and running for the past month. We are up at, excuse me, the Julia de Burgos Latino Cultural Center at Lexington Avenue and 106th Street, and we're open 6 days a week. We're offering a variety of social services, including access to benefits, and of course, legal assistance, legal advice. We are hopeful that with your volunteer efforts that there will be an outlet for what we expect to be, with all due respect to our colleagues at FEMA, a number of FEMA denials and a wave that may crash. And so we are very grateful to the City Bar for allowing us to participate as feeders, if you will, to these Monday night clinics. What I wanted to lend to this was just a little bit of local color. The folks who are affected here are coming into a center, not in some far-flung place. They're coming into a center just uptown from here, and they are the family members and friends of New Yorkers, just like all of us. And in many cases, they will need assistance navigating what is clearly a complex system around FEMA grants and FEMA denials. So I am urging you all to participate. The pizza is part of it, but I think the inspiration to really help your fellow New Yorkers is another. And so we'd ask you to participate as much as you can because that FEMA denial that you may handle and even get turned around may be on behalf of a New Yorker just like you. Thank you.
So that's our program. Thank you, Will. Thank you, my colleagues from FEMA, for coming from Washington. Thank you, our partners here in the city. And most importantly, thank you to all of you.